Hello, ladies and gentlemen. My name is Tim Gagan, and I'm a lawyer in Quebec. What you're going to be watching today is for legal information purpose only. It does not constitute a legal advice. If you have a real case, if you need a real legal advice, please contact your lawyer. If you need more information, here are several useful links. If you need a lawyer and you don't have a lawyer, please contact the Law Society of Quebec, Barreau de Quebec, and they will help you to find one.
So what do we have now? Did you look closely at the beginning? Any indication that would require you to look deeper or to maybe hire an expert? If it was an inspector, did you look diligently through the inspector's report? Did you ask questions? In case of doubt, what did you do? Did you ask the seller? Okay, then you bought the property. Did you go around diligently? Did you open what is suspicious? Did you invite specialists if needed? Did you do good maintenance on your own, which you should have done? And if you uncovered something, first, how grave was it? And second, how soon after the purchase you have uncovered that? Those all are factors to understand if you have a good claim against the seller or not. Again, it's not enough that you know about the problem. It's important that you inform the seller of the problem as soon as possible in a reasonable time, as it says. There is no particular time limit set in law, like what's reasonable time, because usually the time starts to be counted from the moment that you knew or should have known. You see this point of should have known, again about due diligence, should have known about the defect. So, usually, it depends on their significance, of course, but usually it's something about weeks or months. And the way you usually notify the seller, well, legal way you usually notify the seller, is the letter of formal notice, again more commonly known as lettre de mise en demeure, even when we speak English. But technically it's letter of formal notice. So basically on your own or with your lawyer, you write an official letter and send it in a way that you would have proof that you have sent and the other party has received the letter. It might be a bailiff, it might be a registered mail, for example. Sometimes even email, but again, as long as you have proof that it was duly received. For example, you got an answer. There you explain the situation, you explain the problem, you explain why do you think the seller should have done something about that, repaired or compensate, and you should have noticed that, well, normally, that if the seller does not cooperate, you are going to go to court, or, well, you reserve the right to go to court. You have to do this sufficient notice, to send this notice before you started reparations. So first, you have to give the seller some options. Maybe the seller in good faith will come and rectify the problem at his own cost. Maybe that would cost him or her less than you would have spent on that for whatever reason. Maybe it took you time, maybe you forgot, maybe at the beginning you didn't think that it would be this bad, but you missed the good time to make official formal notice, but maybe you informed the seller anyways. So that might help. If you could show eventually, if you are before a judge, that the seller knew the full extent of the problem, maybe you had communication, maybe you exchanged some proposals, then it plays in your favor. But in any case, it would be diligent and wise to send that lettre de mise en demeure, letter of formal notice, just to cover your bases, basically. if the situation is urgent. It's winter, for example, and it's a problem with heating. And the seller apparently is not fast enough to react, and you see that there is a resistance. In that kind of situation, you're justified to start your repairs as soon as possible. But if it's not urgent, then first you have to notify the seller to see the seller's reaction, to negotiate probably. Maybe, if it's not urgent at all, first to go to court, obtain a judgment, and only then use that judgment to do the repairs. Again, it's not built in stone, it's not like black and white, and after all, it's all for the judge to appreciate the situation and to decide if your actions were actually reasonable in the situation or not. But before you know what the judge would say, it's better to be cautious, it's better to be reasonable, it's better to play by the rules as much as you can. Again, as we discussed before, the moment from which the time limit starts is not the moment when you suddenly decided to consider something a problem, and not even sometimes the moment when you actually discovered it, but it might be from the moment when you should have discovered it. For example, you saw that there is a wet stain on your ceiling for quite some time, maybe half a year, and only then you started to do the observations and found out that your roof is leaking. So yes, you found that the roof is leaking in, let's say, late November, but you should have known of it from the moment the water stain started on your ceiling, which would be something May, June. And if this kind of information gets to the seller somehow, or if it's provable that that was the case, then the fact that it took you 6 months to notify could be counted against you, could be taken against you. So again, be diligent as long, like first half a year, year and a half, as long as you really sure that you looked through everywhere and there is no bad surprise that could come up. So look for a bad surprise. Look for it as diligent as you can at the beginning. Don't be relaxed, because this relaxation then could be used against you.